I'm Ryan Rapucci, one of the managing partners and founders of the law firm of Ariano Rapucci. Today I'd like to talk to you about spousal maintenance. We've already had previous videos outlining what somebody needs to establish in order to demonstrate spousal maintenance is appropriate, and if it's appropriate, for how long it should be awarded, and for how much somebody should receive in spousal maintenance during that time. Today's video is more about whether or not spousal maintenance may be terminated during the period of time that the court has ordered. And to answer that question, it determines, or it turns on a number of different factors. For instance, in Arizona, parties can agree to make a spousal maintenance award and the term of spousal maintenance considered non-modifiable. They can do that in their consent decree by agreement, or they can do that by other agreements before the court if they wish. If that specific language, however, is not listed or reflected anywhere, then spousal maintenance is going to be deemed or determined modifiable during the maintenance period. Now, it's modifiable if certain requirements are met, and those statutory requirements are pretty fact sensitive, so it's strongly suggested that you meet with an attorney to discuss. Also, during a spousal maintenance term, unless otherwise agreed by the parties, should either party pass away or should the receiving spouse remarry, then spousal maintenance will terminate. Now, that leads to a peculiar position and concern that I often hear from clients, and is, what if the receiving spouse is not remarried but is romantically cohabitating with another person? Is that sufficient to invoke the statute where spousal maintenance would be void? And the answer to that question is, by statute and by case law and precedent in Arizona, there is no romantic cohabitation requirement. Meaning, as long as the party does not remarry, then they still should receive spousal maintenance. Now, with that said, there's some clever little tricks that attorneys are doing these days when negotiating property settlement agreements and divorces by consent, and that is that we are placing into those agreements certain qualifications or standards or definitions for something called romantic cohabitation. And in the event that those standards are met and it triggers the definition of that clause, then the court may very well uphold it in the event it becomes necessary down the road. Meaning, even if the spouse receiving maintenance doesn't remarry, if they're romantically cohabitating and that is listed in the decree, it might very well be enforced, and therefore the spousal maintenance amount terminated. For more information on spousal maintenance or any other family law matter, please contact us today for your free, no obligation consultation.